Hi, this is Gargi again, and I'm continuing with Law of Contract Unit 2. I'm extremely sorry because I didn't realize that I hadn't recorded Unit 2 and 3. So here we go, and I hope this helps. So this is Unit 2, and here the topic is about consideration. Enforcing any legal contract requires it to have an element of consideration included in it. In simple words, it's nothing but a price that the promisee agrees to pay to the promisor. Now, this price can be paid as a benefit to the promisor and or a loss or detriment to the promisee. In this article, we will look at this dual aspect of consideration in detail. Basic understanding of consideration. According to Section 2D of the Indian Contract Act 1872, consideration is defined as follows. When, at the desire of the promisor, the promisee or any other person has done or abstained from doing, or does or abstains from doing, or promises to do or abstain from doing something, such act or abstinence is called a consideration for the promisee. This is a complex sentence. Let us break it down for further understanding and rewrite it as follows. At the desire of the promisor, if the promisee either A. does something in the past, present, or future, or B. abstains from doing something in the past, present, or future, then this act of doing or abstinence is called consideration. Now it has two aspects, either doing some act or abstaining from doing something. Let us look at some examples. Example 1. Doing something. Peter and John enter into a contract where Peter promises to deliver 15 curtains to John in 1 month's time. Also, John promises to pay Peter an amount of rupees 3,000 on delivery. In this contract, John's promise to pay rupees 3,000 on delivery is a consideration for Peter's promise. Also, Peter's promise of delivering 15 curtains is a consideration of John's promise to pay. Example 2. Not doing something. Peter has taken a loan from his friend John. However, he has not repaid the loan yet. John promises not to file a suit against Peter if he promises to repay the loan within a week. In this case, abstinence on the part of John is due to the consideration of Peter's promise of repayment of the loan. According to Section 2D of the Indian Contract Act 1872, the following features are essential for a valid consideration. 1. Consideration must move at the desire of the promisor. Consideration can be offered by the promisee or a third party only at the request or desire of the promisor. If an action is initiated at the desire of the third party, it is not a consideration. Second, consideration must move at the desire of the consideration may move from the promisee to any other person. If you look at the definition of a consideration according to Section 2D of the Indian Contract Act 1872, it explicitly states the phrase promisee or any other person. This essentially means that in India, consideration may move from the promisee to any other person. However, it is important to note that there can be a stranger to consideration but not a stranger to the contract. Peter gifted his son Oliver an apartment in the city with the condition that he pays a fixed amount of money to his uncle John, every year. On the same day, Oliver executed a deed to pay a fixed amount of money to John every year. However, Oliver failed to pay and John filed a suit for recovery. Oliver pleaded that he was not liable since no consideration had moved from John. However, the court held the words promisee or any other person and allowed John to maintain his suit for recovery. Number 3. It can be in the past, present, or future. A. Past. Since consideration is the price of a promise, it is normally given to induce the promise. However, it can be given before the promise is made by the promisor. This is past consideration. It is important to note that past consideration is not considered for a new promise since it's not been given in lieu of the promise. According to Indian law, past consideration is good consideration if it was given at the desire of the promisor. Peter employs John to work on his field during the months of agricultural harvesting. He promises to pay John an amount of rupees 5,000 for his services when he sows the new crop in the fields. The services of John in the past constitute a valid consideration. A1. Past voluntary services. At times, a person might render voluntary services without any request or promise from another. If the person receiving the services makes a subsequent promise to pay for the services, then such a promise is enforceable in India under Section 25(2) of the Indian Contract Act 1872, which states, "An agreement made without consideration is void unless it's a promise to compensate, wholly or in part, a person who has already voluntarily done something for the promisor or something which the promisor was legally compellable to do, or unless." Peter finds John's wallet on the road. He returns it to him and John promises to pay Peter rupees 500 for his services. This is a valid contract. B. Present. If the promise and consideration take place simultaneously, then it is present or executed consideration. An example is Peter goes to a shop, buys a bag of chips and pays for the same on spot. Future. When the consideration for a promise moves from the contract, when the consideration for a promise moves after the contract is formed, it is a future or executor. It is also valid if it depends on the condition. Peter promises to create architectural plans for John's new house. John promises to pay Peter an amount of rupees 50,000 provided the plans are approved by his wife. Fourth point. It must have now fourth point, all these points, we saw 3 points thus far, are all about characteristics of consideration. Fourth point. It must have value in the eyes of the law. While the law allows the parties to decide an adequate consideration for them, it must be real and have value in the eyes of law. While the court will not consider inadequacy, it will look at it to determine if the consent was given by the party with free will or not. Peter's wife agrees to withdraw the suit she has filed against him in return for his promise to pay her a monthly maintenance amount. This is a good consideration and holds value in the eyes of law. Fifth, it should be over and above the promisor's existing obligations. If the promisor is already obligated either by his promise or law to perform or abstain from a certain act, then it is not a good consideration for a promise. Peter receives a summons from the court to appear before it as a witness for John. John promises to pay him rupees 10,000 to appear in the court. This contract is not valid because Peter is obligated by law to appear in the court on receiving a summons. Sixth point, sixth characteristic, it cannot be unlawful. A consideration that is against the law or public policies is not valid. Peter offers rupees 10,000 to John to beat up his business rival. John beats him up, but Peter refuses to pay him. John cannot file a suit for recovery since the consideration is against the law. Now we are going to look at the capacity to contract law and legal definition. Capacity to contract law and legal definition. Capacity to contract means the legal competence of a person to enter into a valid contract. Usually, the capacity to contract refers to the capacity to enter into legal agreement and the competence to perform some act. The basic element to enter into a valid contract is that he/she must have a sound mind. Certain class of people are exempted from the category of people who are capable of entering into contract. 1. Infants and minors. 2. Insane. 3. People under the influence of drugs. 4. Bankrupt. And 5th, enemy alien. Law relating to minor and unsound mind. According to section 2, every person is competent to contract who is of the age of majority, according to the law to which he is subject, and who is of sound mind and is not disqualified from contracting by any law to which he is subject. So we have three main aspects here. Attaining the age of majority. First one is attaining the age of majority. 2. Being of sound mind. 3. Not disqualified from entering into a contract by any law that he is subject to. Attaining the age of majority. According to the Indian Majority Act 1875, the age of majority in India is defined as 18 years. For the purpose of entering into contract, even a day less than this age disqualifies the person from being a party to the contract. Any person domiciled in India who has not attained the age of 18 years is termed as a minor. Let us look at certain laws governing a minor's agreement. A contract made with a minor is void since any person less than 18 years of age does not have the capacity to contract. Any agreement made with a minor is void ab initio from the beginning. Void ab initio means from the beginning. Ab initio means from the beginning. Void from the beginning. Example: Peter is 17 years and 6 months old. He needs some money to go on a vacation with his friends. He approached a moneylender and borrows rupees 25,000. As security, he signs some papers mortgaging his laptop and motorcycle. 6 months later, when he attains the age of majority, he files a suit declaring that the mortgage executed by him when he was a minor is void and should be cancelled. The court agrees and relieves Peter of all liability to repay the loan. Also, if a minor enters into a contract, then he cannot ratify it even after he attains majority, since the contract is void initio, which means from the beginning, and a void agreement cannot be ratified. A minor can be a beneficiary of a contract. While a minor can not enter a contract, he can be the beneficiary of one. Section 30 of the Indian Partnership Act 1932 also specifies that while a minor cannot become a partner in the partnership firm, the benefits of the firm can be extended to him. Example: Peter lends some money to his neighbor John and asks him to mortgage his house as security. John agrees, and the mortgage deed is made favoring Peter's 10-year-old son Oliver. John fails to repay the loan, and Peter, as a natural guardian of Oliver, files a suit against John to recover his money. The court holds the case since a minor can be a beneficiary of a contract. A minor is also given the benefit of being a minor. Even if a minor falsely represents himself as a major and takes a loan or enters into a contract, he can plead minority. The rule of estoppel cannot be applied against a minor. He can plead his minority in defense. Contract by guardian. Under certain circumstances, a guardian of a minor can enter into a valid contract on behalf of the minor. Such a contract, which the guardian enters into for the benefit of the minor, can also be enforced by the minor. However, guardians cannot bind a minor by a contract for buying immovable property, but a contract entered into by a certified guardian of a minor appointed by the court with approval from the court for the sale of a minor's property can be enforced. Insolvency. A minor cannot be declared insolvent as he cannot avail debts. Also, if some dues are pending from the properties of the minor and he is not personally liable for the same. Joint contract by a minor and an adult. In case of a joint contract between an adult and a minor executed by the guardian on behalf of the minor, the liability of the contract falls on the adult. 2. Person of sound mind. According to Section 12 of the Indian Contract Act 1872, for the purpose of entering into a contract, a person is said to be of sound mind if he is capable of understanding the contract and being able to assess its effects upon his interests. It is important to note that the person who is usually of an unsound mind but occasionally of a sound mind can enter a contract when he is of a sound mind. No person can enter a contract when he is of unsound mind, even if he is so temporarily. A contract made by a person of an unsound mind is void. 3. Disqualified persons. Apart from minors and people with unsound minds, there are other people who cannot enter into a contract, that is, do not have the capacity to contract. The reasons for disqualification can include political status, legal status, etc. Some such persons are foreign sovereigns and ambassadors, alien enemy, convicts, insolvents, etc. So with this we come to the end of Unit 2 of the Law of Contract. And we have just one more unit, Unit 3, and that will end Law of Contract. Once again, sorry for the delay in posting this second unit.